Hello everyone, welcome back to the channel. Today we are discussing a very interesting decision from the NCLAT dealing with a unique situation under the Insolvency and Bankruptcy Code 2016. The case revolves around whether a sole financial creditor, who also happens to be a related party, can push a company into resolution, and if not, what the remedy is. The case came up before the NCLT, Ahmedabad. The appellant had initiated CRP against a company called Strauss Hoests Private Limited. This company was set up as a joint venture vehicle where the appellant itself had 50% shares. Apart from equity, the appellant had also advanced loans to the corporate debtor. Since these loans were not repaid, the appellant filed for CRP. The application was admitted and an IRP was appointed. Now here comes the twist. Where the IRP examined the records, she found that there was only one financial creditor, the appellant. There was no operational creditor. Since the appellant also held 50% share, it was a related party. This meant under section 21 subsection 2 of the IBC, the appellant could not form the committee of creditors. So the IRP approached the NCLT seeking directions. The NCLT appointed an amicus curiae. He suggested that in such a scenario, the only option under the IBC was liquidation of the corporate debtor. He also relied on precedents from other NCLTs. However, the NCLT took a very unusual stand. Instead of directing liquidation, the adjudicating authority asked the appellant to withdraw the CRP altogether. Naturally, the appellant was aggrieved. They had started CRP to recover their dues. Now with this order, they were left without any remedy, so they filed an appeal before the NCLAT. Before the NCLAT, the appellant's counsel made two major observations. Number one, on related party disqualification, he submitted that he relied on the Supreme Court judgment in Phoenix ARC Private Limited versus Spade Financial Services Limited. The Supreme Court had clarified that excluding related parties from CoC was to prevent conflict of interest. But here there was no other creditor at all, so the question of conflict did not even arise. Therefore, constituting a CoC with the sole related party should still be permissible under the intent of the law. The other submission was about withdrawal direction. The NCLT should not have directed withdrawal of CRP. This put the appellant in a hopeless situation, back to square one without any remedy. The resolution professional also appeared and confirmed that apart from the appellant, there was no other creditor. The corporate debtor was not operational and had no running business. The tribunal now faced a tricky issue. What happens when there is only one financial creditor and that too is a related party? The appellant's argument to treat such creditors as part of the CoC was indeed appealing. But the tribunal noted that to accept this, it would have to read into the law something that the legislator had not provided. This is called casus amicus, where courts cannot fill gaps in legislation. That task is for the parliament, not for the judiciary. Now, what does the IBC itself provide? CRP exists primarily to protect and revive a going concern. If the corporate debtor is not operational and has no business activity, there is hardly any scope for resolution. Moreover, without a CoC, the resolution process cannot even take off. Therefore, whether the company is a dead entity or even if it was alive, in both the cases, the process would inevitably lead to liquidation. The NCLAT concluded the order of NCLT was wrong. It created an impasse and left the appellant without any remedy. Judicial bodies cannot declare helplessness. They must provide a workable solution. The only viable option here was liquidation, so the appeal was allowed. The NCLT's order dated 6th of September 2024 was set aside. The matter was remanded back to NCLT Ahmedabad. The adjudicating authority was directed to appoint a liquidator and continue with liquidation process as per IBC provisions. So in summary, this case highlights a lacuna in the IBC. What happens when the only financial creditor is a related party? While the law does not directly provide an answer, the NCLAT has clarified that the solution lies in liquidation, not withdrawal. This ruling is significant because it ensures creditors are not left without remedies just because of a structural gap in the code. Thank you so much.